Press release. To my boxing fans around the world, many of you wonder why and when will I be back in the ring. I will be back when the American Embassy here in Abuja, Nigeria reinstates my pledge of oath of allegiance. Issue: whether or not the United States Ambassador to Nigeria, Her Excellency Mary Beth Leonard, and Deputy Kathleen Fitzgibbon should delay the response of the motion to reopen submitted by Controller General of the Nigerian Immigration Services, Idris Jerry Issa, since December 23, 2021, without any just cause. Here is the fact. Here is the case in fact. On October 5, 2004, the United States Immigration Judge Ellen Wise issued a removal order to me to Nigeria, citing in case number A070-675-261. That order was not appealed by me, nor its execution carried out in 3 months statutory time requirement. I was abandoned in the Nevada Department of Corrections, NDOC, without any remedies to the apparent judicial error 1 evinced therein at law. See 1 Memorandum of Opinion by Patrick F. Philbin, Deputy Assistant Attorney General, Office of Legal Counsel, dated on February 20, 2003, 8 CFR 241A, Section 03-1. Limitations on the detention authority of the Immigration and Naturalization Service, at footnotes 1 and 10, stating 1. Of course, it is also implicit in the granting of any authority to an executive officer that it may not be exercised in a manner that is expressly constitutionally prescribed. Thus, the Attorney General could not, for example, delay the removal of an alien solely as a mechanism for imposing punishment on the alien. CEG Wang Wing v. United States 103 U.S. 238 1896. 10. The provision reads, except as otherwise provided in this section, when an alien is ordered removed, the Attorney General shall remove the alien from the United States within a period of 10 days. On February 8, 2007, the Supreme Court of Nevada in docket 47261 awarded me an order of reversal and remand in the instant case of State v. Ibabuchi, which immigration relied for deportation. However, the remand was to prison rather than to court and lasted until the expiration of time of the plea bargain sentence. The state of Nevada issued to me a certificate of discharge on February 28, 2014, and transferred me to the immigration custody. On April 1, 2015, the United States Citizenship and Immigration Services, USCIS, approved a Form I-539 application to extend, change non-immigrant status, number IOE 7688587967 to me. Although it was not served to me at law, the United States Department of State's USDOS issued a non-immigrant visa 47456 to me on April 14, 2015, and although not served again, the record was updated. I discovered this evidence by the use of computer upon my release from the immigration custody. On April 27, 2015, my waiver of fees to the Board of Immigration Appeals, BIA, was approved under exemption, as were the docket 47261 enumerated above, and disclosed an amount recovered or seized to $70,675,261 261, in which was the prayed relief from the remand in the Supreme Court of Nevada. On August 11, 2015, the BIA decided my appeal and denied same for timeliness and returned jurisdiction for motion to reopen to the immigration judge in Las Vegas, Nevada. On November 9, 2015, I was released to Arizona to commence status update while serving probation on the remainder of Arizona case. This probation was illegal by federal law because the case of Arizona State was disposed on May 9, 2003, to be served concurrently with the Nevada states, and by the concurrent doctrine, therefore, the discharge in 2014 should have concurred. Further, an executive action is one that invalidates an existing order of removal, citing the April 1, 2015, April 14, 2015 executive actions by the USCIS and USDOS. On January 27, 2016, I was biometrically processed by USCIS in Phoenix, Arizona for replacement of an expired or lost legal permanent resident card (LPR) as provided in 8 CFR Section 264.5b 1 2 for Form I-90 application number IOE 0900312267. On March 23, 2016, I was later biometrically processed for naturalization as granted on Form N400 a month later. Earlier, see in MBC asterisk 0065908855. It should be noted, respectively, that I chose to change my non-immigrant status rather than extend as stated on the appropriated executive action of April 1, 2015. I was not stinted to extension therein at law. On September 3, 2016, I received a brand new permanent resident card number 54108-362 in a priority mail from USCIS and with a parole evidence number 2B0416. On February 13, 2017, I was scheduled to appear for my initial naturalization interview. However, I was in jail in stupor for alleged probation violation. Reason: ungranted access to computer usage. Computer was only granted in the library only, not at home. Consequently, I was not in receipt of the notice of action I-797C for the taking of oath of allegiance as dispatched to me in the mail. On February 16, 2018, I was sentenced to prison on the probation violation by the Superior Court Commissioner John R. Doody to complete the statutory time for a lifetime probation as reached in the agreement in 2003, which was for 3.5 years, whose cause accordingly was intransigent to sentencing guidelines, collateral estoppel, double jeopardy, and dual sovereignty of the federal law. For sentencing guidelines, probation should not be signed at the same time with an imprisonment lasting over 30 years. Yet, this instant probation was signed and executed on May 9, 2003, while a 2-year imprisonment was imposed to be served concurrently with Nevada State. On August 25, 2020, the Supreme Court of Arizona awarded a remand in my petition for post-conviction relief (PCR) case number CR-19-0240-PR for a statutory credit in the matter, and which the Superior Court applied and granted in a status conference on August 31, 2020 in absolute discharge. Said absolute discharge was abandoned by the Sheriff Paul Penzan therein. On September 23, 2020, the United States Immigration and Customs Enforcement USICE Assets Agency unwittingly arrested me from prison, stating that the immigration judge wanted to see me, but until my departure, no immigration hearings were held. I filed an appeal to the Ninth Circuit Court in number 20-73282 Ibabuchi v. Barr, alleging wrongful detention, but the federal government countered for a dismissal on timeliness. The court favored the government and sustained the Board of Immigration Appeals BIA decision of August 11, 2015 in the matter as final decision. On February 4, 2021, the United States Department of Homeland Security, USDHS, upon my request for Freedom of Information and Privacy Act, FOIA PA, provided me with copies of exempt and non-exempt records. There, I discovered that I was scheduled for an initial naturalization interview on February 13, 2017, and a per se no-show caused my application to be administratively closed on August 28, 2017. On August 7, 2021, I was arrested from Eloy Detention Center (EDC) for a discharge as informed by the captain of the center to Florence Staging Facility (FSF) in Phoenix, Arizona. On August 11, 2021, I was arrested for Nigeria on deportation by the Special Response Team (SRT). I presented my FOIA PA exempt copies of scheduled initial naturalization interview and proof of legal permanent resident card, and reported that for a year in detention I was not brought to any immigration hearings as a matter of law. I was responded by the head of the squad that I was going to where I would be heard. So there you had it, my boxing fans. I was informed by the officer in charge of the operation after reviewing the proof of evidence I had for naturalization that I was being transported to the venue where someone will hear my case. So I was not deported yet. My case is being reviewed as informed. On August 18, 2021, I was heard by the Nigerian Immigration Services Acting Deputy Controller General Mohammed Aminu, and again by his successor, Acting Deputy Controller General Chinwobi, on October 14, 2021. The matter was upheld and transferred to the legal advisor, Malam Adamu, wherein he submitted fact findings and conclusions of law for a request to the Controller General (CG) Acting Idris Jerry Issa for approval. On December 23, 2021, the acting CG approved and signed the request to the ambassador of the American Embassy for a dispassionate review. This is the motion to reopen. On December 24, 2021, the American Embassy by Mr. Ibrahim Onoja received the transmittal on behalf of the ambassador Mary Beth Leonard, plenipotentiary of the United States of America. On March 14, 2022, due to lack of response from the United States Embassy, the legal advisor, by permission from the acting CG, submitted a follow-up in the matter. On March 21, 2022, said follow-up was received and signed by the American Embassy. Till now, there has been no response from the American Embassy, which is tantamount to an abuse of discretion.